Stand your ground in the news again on several fronts. I begin with this. The political theater witnessed this week in Washington, D.C., this time in the Senate hearing room of the Judiciary Committee, was nothing short of that, ladies and gentlemen, theater. Theater controlled by gun-hating Democrat Chairman Dick Durbin of where other than Illinois, with theater defined by Webster's dictionary as a building or a place used for dramatic purposes. Webster's also defines theater as spectacle, with the definition meaning a very impressive show. A spectacle this hearing was indeed. Trying to convince them that somehow the right to defend your life against deadly attack anywhere you have a lawful right to be, anywhere outside of your home, needs to be amended, thereby adding to the victim mentality so necessary for their agenda to move forward. Nowhere was this phony spectacle more vividly displayed than the trotting out, if you will, of Trayvon Martin's mother to discuss the topic of stand your ground at a stand your ground hearing. Take a listen to this.
As I think about this as a mother, and I think about how many kids walk to the store and how many kids now feel that they cannot be safe in their own community, I think about what kind of message we are sending as parents, as lawmakers, as elected officials, even as grandparents and aunts and uncles. What kind of message are we sending if our kids, because remember, these are our kids in our communities, don't feel safe? Don't feel safe simply walking to the store to get candy and a drink. So I just wanted to come here to talk to you for a moment to let you know how important it is that we amend this stand your ground, because it certainly did not work in my case.
Stop right there. I said nowhere was this phony spectacle more vividly displayed than the trotting out of Trayvon Martin's mother to discuss the topic of stand your ground at a stand your ground hearing. She lost her son. Mark, come on, certainly there's nothing phony about that. Ladies and gentlemen, I'm not here to debate the Zimmerman case, the Zimmerman-Martin case again. That's settled law. And that case was decided by a jury. It's a done deal. It's over. And Durbin and the gun-hating, self-defense haters across this country need to get over it. So why is her appearance and statements phony? For one simple reason. Her son's case was never stand your ground. Never. Her son's victim never invoked the law. That's right, I said her son's victim never invoked the law. His attorneys never sought to invoke it, and it was never an issue in this case. Her statements, used by the unscrupulous Democrat gun-hating machine about a law that was never used to defend the man who killed her son after he was attacked. That fact, by the way, found by a Florida jury, not this host. Her statements were used to exploit a case by the masters of exploitation. The masters of exploitation, the Democrats, the gun haters, the absolute masters of exploitation. This was a case that received tremendous media coverage. They used her in such a way as to influence. Now think about this, what I'm saying to you. They used her in such a way as to influence their infamously low information core constituency. Her statements in front of that Senate Judiciary hearing have as much credibility regarding the topic of stand your ground as my testimony would if I were called to discuss the impact of the plight of the farmer, because I played one in a movie. Oh, wait, they did that too, remember? Seeking to influence the notoriously low information voter. It was the Democrats who brought 3 actresses who played distressed farmers' wives in a movie. Did you hear me? Played them in a movie. Remember this? Sissy Spacek, Jessica Lange, and Jane Fonda, the latter speaking volumes by itself, to testify in front of a Democrat-controlled hearing about the plight of farmers. 3 actresses who know nothing about farming, one being a documented traitor to her nation. Are you shocked? The Dick Durbin-controlled committee would exploit a case that had nothing to do with stand your ground in a supposed attempt to investigate stand your ground laws? I'm not. Not with this current Democrat crop that has been taken over by the progressive socialists who justify lies and deceit to advance their agenda, i.e., along the lines of if you have health care plan, you can keep it. Lies and deception to advance an agenda, in this case, an anti-gun agenda. Another tool, yet another tool in their toolbox to come after your right to defend your life. Can't get your guns through federal legislation, so the tactic turns to limiting or eliminating your right to use one to defend your life outside your home. And this is another tool in the toolbox. To these people, their means justify their ends. And with the help of the mainstream media, they are succeeding. And they are very well aware of the level of stupidity, and they're counting on it. They're counting on your stupidity. Joining me tonight to discuss this topic, among many others, is my in-studio guest, pro-gun attorney John Monroe himself. He's going to fight against a challenge, if you will, to Georgia's Stand Your Ground law by none other than race baiter, gun hater, master of exploitation, and father of a recently convicted felon and fraudster, the self-proclaimed civil rights leader who bears his name, Jesse Jackson, and to discuss his own testimony in front of that very committee earlier this week. Fox News contributor and writer, author of More Guns, Less Crime, now in its 3rd edition, Dr. John Lott will be here to set the record straight, just as he did in front of that phony hearing a few days ago. In the studio with me here is pro-gun attorney, Georgia Carey attorney, good friend of mine. You've heard him on the show many times, and I have the luxury of having John in the studio with me. John, it's a pleasure to have you here again. Thank you so much for coming, especially on short notice.
Thanks for having me, Mark.
Let's talk about this. And you heard my comments at the beginning, and when we played Trayvon Martin's mom's testimony, or statements, I should say, I saw you over there cringing, and I saw you looking at me, and you were kind of going, wow, why?
Well, I mean, you've already said it wasn't a stand your ground case. If you accept George Zimmerman's testimony, and apparently the jury did, he was on his back, on the ground, having his head bashed into the sidewalk. Suppose he had a duty to retreat. Where was he retreating to? His back was already against the wall. It wasn't a stand your ground case.
Why is she talking to a Senate Judiciary Committee at a hearing titled Stand Your Ground?
Well, who knows, but to me the bigger question is, why is the United States Senate having hearings on Stand Your Ground? That's purely a state issue, and it's a defense to a criminal prosecution. States aren't even constitutionally required to have criminal laws. There doesn't have to be a law against murder if the state doesn't want to have one, but every state chooses to have one, and the state can also choose to have whatever defenses it wants to have against those crimes.
Okay, so now we've segued into that, and that's something that you and I talked about right before we went live, and that is a great discussion. Ladies and gentlemen, we're questioning why, yet again, the Democrats, this is guns. This is about guns. This is about freedom. That's what they're making this about when it comes to quote-unquote stand your ground. John Monroe is going to set us straight on stand your ground laws, or supposed stand your ground laws, across the country, regardless of what state you are in. So we have to ask why, John, and I'll ask you why you think it is that Dick Durbin is chairing these hearings about stand your ground when it isn't a federal government issue. What do you think is there a dubious reason here?
Well, I think he's probably taking advantage of his position to have a national debate or display about it, presumably in an attempt to get states to try to do something about it, or churn up some kind of frenzy maybe to get Jesse Jackson to do what Jesse Jackson did. You got to wonder, though, why Jesse's bothering with Georgia first when he could have stayed home in Chicago and sued his own state, because Illinois has a stand your ground law.
All right. I love the way you're moving. You're moving this right on, and I love this because we have so much to cover with you. Let's go there. First off, I'll give you my reason for Dick Durbin. I think the reason that Dick Durbin is doing this is because, yet again, as you said, he's ginning up trouble. He's using his position as a sort of bully pulpit. This is another tool. I said it in my opening statements, that they will use every tool in their toolbox, because nothing's going to come out of the Senate. hearing on this.
No, they'll never even think about introducing legislation. What can they do?
Of course not. They can't do anything about it. So, again, you have to wonder what it's for. Clearly, this is just another method or another form of propaganda using the media to gin up and I use the word phony, and I'll use it again, a phony debate that they can't do anything about. So all they're doing is just dredging up publicity here at a state level, as you said, and as if we don't have bigger and better things we have to worry about at the federal level than using the federal government to gin up an argument at the state level. Now, let's take that argument to the state level you referred to, and I did in my opening statements. Jesse Jackson.
Well, they say they filed it. It doesn't appear to be on the court's records yet, but they claim on Friday that they filed a lawsuit against the governor and attorney general of Georgia to have Georgia's so-called stand your ground law declared unconstitutional.
Is this the first state he's filed it against at this point, do you know, or will be filing?
It is the first state, although apparently he's planning to do it in every state. God knows why he picked Georgia to go first.
Any theory as to why he would have picked Georgia to go first? Is there anything you can? He obviously did it for a reason. This guy knows how to race bait. This guy knows how to go after money. There's got to be a reason he did this. I can't come up with one yet. I have to give it a little bit more thought. But your thoughts, because you successfully defended a case. We'll talk about that in a minute.
Well, that might be one of the reasons I'll get to in a second. I mean, he could have started with his own home state of Illinois and never left the state. It strikes me as it would have been logical to start with Florida because they claim the Trayvon Martin case was a stand-your-ground case.
Which it was not. It never was.
The only reason I can think of why he might have started in Georgia is, as you mentioned, there was an earlier case last year where a local pastor sued the governor and the attorney general trying to have the law declared unconstitutional, and that case was dismissed. It's the same attorney who brought the first case who's now doing the second case.
What is that attorney's name?
Robert Patillo.
Robert Patillo. Now, you debated on Channel 11 local NBC News here a couple days ago. Friday?
It was Friday night, yeah.
Friday evening, you debated, what's his name, Patillo?
Yes.
On, in a what do you call it, a debate. You were sitting at the table, he was at the table, and the reporter asked you a question and him a question.
It was a 3-minute news segment.
It's hardly a debate. Hardly a debate by any stretch of the imagination. However, he felt that he has, quote unquote, what's he going to say? No, I don't have a chance. He claims he does have a chance, and he feels and he believes that the state, that his suit will overturn stand your ground. And you made some very good points. Now, we've only got a couple minutes before we go to a break, and I don't want to leave listeners hanging with that because I want you to explain about 150 years old or 200 years old or 1776, as you mentioned, and why it doesn't make any difference, not only in Georgia, but across the country, if, in fact, they were successful in overturning one of these laws. And I want you to explain to listeners why. But during that conversation, he seemed very, very confident. As an attorney, is he just saying that? Does he feel that? He knows that you've beat this back once before.
Well, the newscaster asked him if he had a chance. He can't say no. I mean, for one thing, he'd be admitting to filing a frivolous lawsuit in federal court for which he could be sanctioned. But he says he has a chance, but in the first case, he never even bothered serving the defendants. He never served a summons on the defendants. The case just got dismissed because he didn't even get jurisdiction over them.
Did you have something to do with the dismissal in that case?
Yeah, I filed a motion to intervene on the behalf of GeorgiaCarry.org and then filed a motion to dismiss, first on the grounds that they didn't have standing, and then secondly, when they didn't bother serving within 120 days of the federal rules required. That motion was granted in the cases.
Why should a Georgia resident, I don't want to use the term not be concerned. Of course we want to be concerned. But let's assume that Patillo is successful on the second attempt, which I don't think he will be, but what do I know? What if he is successful and the law is overturned by a judge? What happens?
Well, we have to know what law we're talking about, and what they're suing to have ruled unconstitutional is a statute that the Georgia legislature passed in 2006. And all that statute did was codify the existing common law. What that means is when the country was founded in 1776, we inherited the common law of England. Whatever the law was in England, that was the law here. The law in England then was no duty to retreat. It had been the law in England since at least the time of Henry VIII, when it was codified there. So Georgia, throughout all of its history, never had a duty to retreat, and now the legislature has written a law that says there's no duty to retreat. If Patillo is successful in overturning that law, then all we do is go back to what it was before 2006, which was no duty to retreat.
So we've got 200 years of common law that's going to trump what they wrote into a statute simply to make it official? Is that to the in non-legalese, to those of us who are not attorneys, is that basically how it breaks down? This is the law. We're going to say it's the law by writing it in here, even though it's really the implied law because it has been for so long.
Well, kind of. I mean, we start with you don't have to write the laws. We're going to just inherit the law from England, and that was there's no duty to retreat. In 2006, after the Republicans took over the legislature in Georgia, they were worried that perhaps a liberal activist judge would someday overturn that, which judges have the theoretical power to do.
Why would they worry about a liberal activist judge?
Well, you hear tell of one or two out there. So anyway, they pass a law to make it the law in the code book saying there's no duty to retreat. Okay, that's fine. If that law gets ruled unconstitutional, then we still have the common law that says there's no duty to retreat. So we've got two layers of law.
Okay, so it's as we said in simplistic form, it just basically says let's just cement this thing.
Right.
Okay, it's here. Let's cement it, and let's just give it a little home here, and we'll call it OCG, whatever.
Yep.
Now, Florida passed their stand your ground law, of course, went into effect in October of 2005. Was Georgia and the remaining states that codified it as well doing it because Florida did it? You know, Florida back in 1987 modernized and gave us the form of concealed carry that we know today that steamrolled across the country after Florida's law in 1987 was so popular.
Yeah, it's not unheard of for one state to do something and other states, look around, or people who lobby for laws in that state look around and say, hey, Florida did this. That's not a bad idea. We should do that here too.
Okay, well, we're going to talk with you, and I will both talk with John Lott about how effective the stand your ground law has actually been in Florida. The Tampa Times found in a study, and they did, without a doubt, the most comprehensive study done on Florida's stand your ground. They looked at virtually every case they could get their hands on, broke down those numbers into various categories, and used it as a tool to attack Florida's stand your ground. However, they didn't realize that they would be dealing with the brilliant mind of somebody like John Lott, who went in and broke those numbers down even further and found the truth. And we'll go over some of those studies. John talked about that study in his Senate testimony. It will be a very fascinating conversation. Sean, your take on some of the stand your ground. Let's get your opinion on why Jesse Hy Jackson would do this.
Fame, him and Sharpton, all these guys they don't want to let go of the fame. They also understand as long as they can keep my community angry about past things, we will never progress as a community, period.
That's a fear they have, because if you do progress as a community, they lose what?
They lose everything. They lose the status, they lose the money, they lose everything. It's basically, when we were playing Trayvon Martin's mother's testimony, I was just shaking my head here, because you're basically saying I have no right to defend myself when, of all places, some of the neighborhoods that we live in, you have no choice. I mean, think about McDonald. That's what the whole case for Chicago versus McDonald was.
John, you want to jump in about McDonald? He's talking about the McDonald decision in 2010, which took Heller basically and expanded through the 14th Amendment the Second Amendment protections to the states and to localities rather than the federal enclaves. You want to explain what he's talking about a little bit?
Yeah, well, Heller decided that it was unconstitutional for D.C. to ban possession of handguns at all, which it effectively did. Illinois had the same kind of law in its state, and McDonald extrapolated Heller and applied it to all of the states, including Illinois, and said it was unconstitutional for Illinois to ban possession of handguns.
And by doing so, under the 14th Amendment, that's equal protection, wasn't it? Didn't they go after? How did Allen first argue that case?
Primary argument was the privileges or immunities clause.
Privileges and immunities clause 14.
Amendment.
Right, okay. All right, well, obviously that case was successful. 2010, the McDonald case was successful. And Sean, you feel what in the black community today when you hear Jesse Jackson going after this? And I'm going to give you I'm going to give you a spoiler here. John Lott will come on the show and explain why Trayvon Martin's mother and the rest of them are wrong, that it is the black community who is hurt worse.
Absolutely, because like I said, the crime is out. I mean, the crime is outrageous in the black community, and as long as we live in this fairy tale that crime doesn't happen, And as long as Jesse Jackson and Al Sharpton and the rest of these guys that get on here and talk about these guys don't have to deal with this. And as much as I watch MSNBC, every time something goes on with a gun, I never hear anybody explain to me why Chicago's the way it is. If we go by the narratives that these people say that gun-free zones are good, then if that's the case, Chicago you should be able to walk down the street in Chicago and have no problem. But they won't explain, and I personally have sent emails, explain to me why Chicago's so bad.
Does Jesse Jackson know what he is doing?
No.
He doesn't know what he's doing? Does he honestly believe what he's doing is a good thing for the black community? To think otherwise then makes him evil.
Exactly. I mean, you just he just, like I said, as long as he keeps the narrative the way it is, along with MSNBC and the rest of these guys, they win. That's all it is.
Dr. John Lott, economist, author of More Guns, Less Crime, now in its 3rd edition. Fantastic book. If you don't have it, you have to get it. Read it, and you'll understand why. But Dr. John Lott, I understand we've got him for just a very short period of time, so we're going to go to him right now. Dr. John Lott, welcome back to the show, my friend. Always a pleasure to have you here.
Great to talk to you.
Okay, John, you testified. I'm going to turn it over to you. You testified or spoke to this committee in front of them this week, and I have to say this. Why were you talking to a Senate committee about stand your ground when it's a state's issue, and can you give us the gist quickly of what you let them know?
All right. Well, I mean, on your first point, I don't know. I think we've long, unfortunately, gotten past the point of what the federal government should do and what the state should do. I mean, it's not like there are too many laws that you can point to these days that kind of recognize what power states have. Federal government pretty much gets involved with whatever it wants to anymore. Given that, federal politicians saw, something that they could get involved with in order to try to make a political statement. And, gun control is, just one area where they feel that they have to speak out on. Unfortunately, this whole hearing was a little bit surreal in the sense that it just showed to me how far people are willing to go to kind of grasp onto anything to justify new gun control regulations. And you also had a situation where you had 2 women who had tragically lost their sons. I mean, I can't imagine what it'd be like for anybody to lose a child under any circumstances, whether it's justified or not. But their testimony really had nothing to do with stand your ground laws. And yet they were being put forward by Democrats as some way of trying to justify the supposed racial implications of stand your ground laws. I mean, here's the basic point, and that is, if you look at it, blacks benefit more than others do as a group from stand your ground laws. And the reason is very simple, and that is, what you find is that poor blacks who live in high-crime urban areas are much more likely to be victims of violent crime. Everybody knows that. And they also benefit more from owning guns to be able to protect themselves because the police, even though they're extremely important in stopping crime, just can't be there all the time. And so if you look at Florida, for example, blacks make about 16% of the population, but they make up about 31% of the people who avail themselves of stand your ground laws. And you find that blacks are much more likely than whites to be acquitted when they use stand your ground as a defense. I don't know how you can get around those things. Often what's focused on here is that they'll say that if you kill a black, the probability of conviction is lower than if somebody kills a white. And somehow that's taken as evidence of discrimination. There are a couple points to make out. One, the simplest one, is just that it's not whites who are killing blacks or blacks who are killing whites. Almost all these murders for both groups are within racial groups. You have over 91% of blacks who are killed by other blacks and 84% of whites who are killed by other whites. And so if you just take the logic there, that also means that most of the people who are being found innocent because of stand your ground are blacks when you're talking about the killings of other blacks. But even that's too simple, because that's assuming that all these cases are identical. If you go and look through the Tampa Bay Tribune data set that they put together, if you're looking at the shootings of blacks, the blacks in those cases were much more likely to be armed. People who were being shot had guns themselves. They were also much more likely to be involved in crimes that were being committed at the time of the shooting. And, they were more likely to have witnesses there. And, there's a whole strange list of other things that I could point out that show that these cases weren't the same. So it seems pretty clear that you had black victims who were being threatened by black attackers. And why shouldn't we be concerned with letting people be able to go and defend themselves? But, when you look at the history of these laws were passed by overwhelming Republican and Democratic majorities. These weren't political issues until the last year or so. Both Republicans and Democrats cared about these individuals, these victims, having the ability to go and protect themselves. So in Florida, you had a unanimous vote in the state Senate to go and pass concealed carry. In 2004 in Illinois, when Barack Obama was in the Illinois State Senate, you had a unanimous vote there to go and make the stand your ground law in Illinois much tougher in terms of granting immunity to those who were defending themselves. And yet, somehow, bizarrely, this has turned into political football and a racial issue when, if anything, the racial evidence strongly points to the opposite direction from what gun control advocates are claiming. And it's really sad, because politics being brought into this is going to make it so the most vulnerable people in our society, to the extent that they're able to go and change these laws, they're the ones who are going to be victims.
John, do you get the idea? Because I asked the same question. I watched the testimony. I watched you. Your testimony, as usual, was brilliant. You confound these people. The Tampa Bay Times did everything they could to try to turn the findings of their very good study. I read the study. I'll be referring to it after you have left us here. But you turned it upside down. Do you get the idea that they're trying intentionally to muck this issue up simply to come after our firearms and use this as just yet another tool in the toolbox to do it?
Unfortunately, I think that's the case. I mean, look, if you look at the race of the victims and compare them, see the conviction rates for those, you're telling me that they didn't look at the race of those who were defending themselves? To go only report and make a big deal about the fact that, well, if a black victim is killed, there's not conviction. These guys had to know it's their data. I don't believe for a second that they didn't also go and say, well, that means that blacks who are defending themselves are less likely to get convicted. And so the implication is that, if you're going to go and argue, as I told the Senate committee, that somehow there's racial discrimination when you look at, say, a black victim, when there's a black victim, you have a lower conviction rate, you say that that's discrimination against blacks. And wouldn't it imply that you have discrimination in favor of blacks somehow? I'm not saying discrimination is occurring in either case, but discrimination in favor of blacks, that when a black uses self-defense themselves, that they're less likely to get convicted than whites? You can't, it's just this cherry picking of this data and picking out the one fact that they think will outrage people is very sad, because, we have too much at stake in terms of people's safety here to turn all these things into political issues.
No matter the facts and the 30 years of research, John Monroe here in the studio, no matter the facts that he puts forth, indisputable, confounding to the left that they can only resort to calling him a liar and an idiot, simply because they can't refute that argument that he makes based on the data sets that he used and the conclusions that he draws. He was nothing more than a checkbox to Dick Durbin and the rest of the gun-hating Democrats on that. Oh, well, we had him in here. Well, we can say we did. but here's what we're going to do anyway. They are not interested in hearing the facts from this man. They don't care, which is proof positive, John, that to me it's all propaganda and it's purely partisan agenda driven, is it not?
Yeah, they're just trying to stir up controversy.
His conversation here concerned me for a number of reasons. I've had many conversations with John, and you could hear, you could hear the sense of urgency in his voice, I guess, as a way to describe how he sounded relative to, how dangerous he feels the direction we're heading in is. Is that how would you describe what you heard? Well,
I think you've said he tends to give others a benefit of the doubt over their collection of data and their interpretation of it, but he was pretty clear, they just basically took their data and then just turned it into whatever they wanted it to be.
The Tampa Times went after it, and again, this is not unusual, and this is where John will give the benefit of the doubt that you refer to. The Tampa Times, when they did this, went at this to look for so that they could push a partisan agenda to prove why their point that because they don't like stand your ground, when in reality the findings were far different. And although they spun it a particular way in the newspaper, we'll go into some of those things that they some of the data that they came up with in just a few minutes. But John found, by digging deeper, that they were in fact wrong. And as you heard him say, there is no way the folks who did the study couldn't have known those things. And when you hear that, now you know, and his response to my question is this all they're trying to do is muck this up to push this agenda? And that's what concerned me when he said, you can hear the frustration and the concern at the same time. I'm afraid that's right. I don't take statements like that from John Lott lightly if you've read his work. Ladies and gentlemen, I'm going to ask you again to read particularly the third edition. They're must-reads. These books belong on your shelf. Buy the hard copies of More Guns, Less Crime, now in its third edition, Understanding Crime and Gun Control Laws. And I want to read one of the endorsements from inside the cover of the third edition. John Lott has done the most extensive, thorough, and sophisticated study we have on the effects of loosening gun control laws. Regardless of whether one agrees with his conclusions, his work is mandatory reading for anyone who is open-minded and serious about the gun control issue. Especially fascinating is his account of the often unscrupulous reactions to his research by gun control advocates, academic critics, and the news media. That's from Gary Kleck, oft cited on this show, professor of criminology and criminal justice at Florida State University. Gary Kleck is a committed left-wing liberal guy. And John Monroe, you may know that Gary Kleck is the individual who gave us the infamous number in his study from the mid-'90s that found a defensive gun use on average of 2.5 million times across America by good guys with guns versus bad guys. Ladies and gentlemen, if you break that number down, it comes out to approximately 5,000 defensive gun uses per day in this country. That was from the mid-'90s. I would submit to you that number is higher now. Gary Kleck is a committed left-wing guy. He went into this to do the study, and he reported his findings. He didn't report his findings from a biased position. So to hear him say, especially fascinating is his account of the often unscrupulous reactions to his research by gun control advocates, academic critics, and the news media. It's quite telling, coming from a colleague, particularly one who is committed left and reported honestly his findings on defensive gun uses in this country. And incidentally, he found that in those 2.5 million cases, that the gun 95% of the time, John, was never fired. And that was the case in mine, too. I became a statistic. I became one of those 2.5 million where I was able to show my firearm and the commission of a potential crime against me without having to fire a shot. And I'll have that debate with anybody.
I'm one of those statistics, too, by the way.
Yeah, exactly. You are. You want to tell us what happened real quick?
Actually, I was driving in Florida and I was stopped at a stoplight. It was summer. I was younger, didn't have a car that had air conditioning, so my windows were down. And I stopped at a stoplight. Someone came up to the passenger door and opened the door and started getting in the car. And I picked up a revolver I had in my car and pointed at him, and he
fled.
He went in the opposite direction from coming into the car.
He no longer wanted to get in the car, and you never had to fire a shot.
Yeah.
Let me go back to Gary Kleck again. Regardless of whether one agrees with his conclusions, his work is mandatory reading for anyone who is open-minded and serious, more importantly than any of those other descriptions, serious about the gun control issue. And this is what these hearings are about. I think that's where John Lott was going with that. Would you agree?
Yeah.
That they are playing to your emotions? That's what I mean by mucking this all up to try to push this agenda.
Well, they bring out cases and talk about the facts with their spin on them that make it sound like the whole self-defense, stand your ground thing isn't being applied fairly or correctly.
But they're successful in that because of the power. When they've got 3 networks pushing that same agenda and an emotional, you can't say an emotional thinker, a feeler, right, Sean?
Well, yeah. Well, here's
a butterfly. We'll call him a butterfly. When a butterfly sees the same thing on ABC, NBC, and CBS, and that's all they're watching, or they flip to CNN and then flip over to MSNBC because they wouldn't dare watch Fox News, they see the same thing. That perception becomes reality. And the mainstream media is very well aware of this. This goes back to Germany in the 30s. Control the media, control the message, control the message, control the people. I mean, it's that simple. Yeah. And that, of course, is the definition, the classic definition of propaganda, and they know what they're doing.
Mark.
Sean, go ahead.
That's why I said that people can't think, because if you think about it, the average person on MSNBC doesn't even live in a neighborhood where he has to have a gun. But your people that are listening and watching him think, oh, yeah, he's one of us. And that's
I can say the same thing about, I don't know, does Bill O'Reilly live in a neighborhood? He's probably got a gate in front of his house. If I'm making $37 million a year plus gazillions on books, I'm going to at least build a wrought iron fence.
Yeah, but see, he can't play that trick on conservatives because conservatives can think. There's a difference.
Okay, all right. Well, you have a great point there. Let's go to John Lott's. Sean, can you cue up his testimony? I want to play his testimony. Ladies and gentlemen, think about what you hear right now. This is John Lott in front of the U.S. Senate.
Our next witness is John Lott. Mr. Lott is the president of a newly formed organization, the Crime Prevention Research Center. He previously served in research or a teaching position at the University of Chicago and Yale, among other schools. He was the chief economist at the U.S. Sentencing Commission from 1988 to 1990. He's currently a weekly columnist and contributor for FoxNews.com. He received his PhD in economics from UCLA. Mr. Lott, please proceed.
Thank you very much, Chairman Durbin and Ranking Member Cruz and other distinguished members. Stand your ground laws will help people be able to defend themselves. It's the people who are most likely to be victims of violent crime, primarily poor blacks, who benefit the most from having the option to be able to protect themselves. What's been lost in part of this discussion so far is the reason why states have adopted these laws. Requiring people to retreat as far as possible creates confusion, creates doubt, and can make it more difficult for people to be able to go and defend themselves. In Florida, blacks made up about 16% of the population, but they account for 31% of the state's defendants invoking stand your ground laws. Black defendants who invoke the statute to justify their actions are actually acquitted almost 8 percentage points more often than whites. The Tampa Bay Tribune has put together very detailed data on stand your ground cases. Up through July 24th of this year, from beginning of 2006, the newspaper had collected 112 cases. The information that they had that often constitutes their shocking finding is that 72% of those who killed a black person faced no penalty, compared to 59% of those who killed a white person. 80% of those who killed Hispanics were also not convicted. What one needs to remember, however, in this is that the vast majority of these crimes are within race. So, for example, 90% of blacks who were killed in stand your ground cases who invoked stand your ground were killed by other blacks. In the case of whites, it was 85%. In the case of Hispanics, it was 100%. The basic point is that if you're going to concentrate on the fact that relatively few people who kill blacks are going to be convicted using stand your ground defenses, you have to realize that almost all those people who aren't being convicted are blacks. 69% of blacks who raised the stand your ground defense were not convicted. That compares to a little bit less than 62% for whites. 80% of Hispanics who raised the stand your ground defense are not convicted. If blacks are supposedly being discriminated against because their killers so often are not facing any penalty, wouldn't it also follow that blacks are being discriminated in favor of when blacks who claim self-defense under the stand your ground law are convicted at much lower rates? than other racial groups. The problem also is not all these cases are the same. Blacks are killed in confrontations where were 13 percentage points more likely to be armed than whites. By a 43 to 16% margin, blacks killed by other blacks, were also more often in the process of committing another crime. They also were involved in cases where it's much more likely to have a witness present. If you go and run regressions where you try to account for all the factors that are brought up in the Tampa Bay Tribune data set, what you find is that white defendants are more likely to be convicted by black defendants, and people invoking stand-your-ground laws who kill blacks were also more likely to be convicted than those who killed whites. What you find when you look at it, and fortunately this is the case, the people who initiated the confrontation were more likely to be convicted. And when there were eyewitnesses, they were less likely to be convicted. Armed individuals, and when more than one person was killed, also were much more likely to result in convictions. The Urban Institute report that was brought up earlier, I think actually shows the opposite of what has been quoted here. One of the important things just to mention, John Roman, who wrote this, noted stand-your-ground laws appears to exacerbate, he said they appear to exacerbate racial differences, but he acknowledges his data lacks details available in the Tampa Bay Tribune data. Quote, the data here cannot completely address this problem because the setting of the incident cannot be observed. And if you go through his paper, what you find, he has no data, no information on whether an eyewitness saw the confrontation, no data on whether there was a physical evidence. He has no evidence on a whole range of things in order to try to factor those into account. The big thing, if you look at his study, the central finding is to look at Table 3. And what you find is that when blacks are under stand-your-ground laws, their situation in terms of conviction rates actually fall. If you look at the Texas A&M study that was mentioned, they do not account for any other gun control laws. If you're going to look at stand-your-ground laws, whether you have right to carry, the number of people who have permits is going to be important. And when you account for those things, their results disappear. If you're talking about Castle Doctrines, whether people are able to get quick access to guns is going to be important. And again, nothing about gun lock or safe storage laws are accounted for in those studies. And when you do that, their results also disappear.
I want to thank John Lott for not only his appearance on the show today, but for the testimony that he gave. And he catches a lot of heat from other academians who just can't stand this stuff because of their own personal bias towards guns. They've never studied it for 30 years like he did. They just don't like his findings, so they attack him personally. He puts up with a lot of heat.
Yeah.
And it takes a lot to stand up, but when he has the facts on his side, he'll go to any venue that wants him and speak facts to anybody. Interestingly, where he got most of that information from this was from a study that the Tampa Bay Times did. And the Tampa Bay Times, rabidly anti-gun, St. Pete Times, did a very comprehensive study, but they did it from the basis of trying to bolster their gun-hating agenda, quite frankly. And John Lott picked them apart, ate their lunch. Here's some of the statistics that they found. This is coming from the study. Did the victim initiate the confrontation? Quoting, Trayvon Martin's death became controversial because circumstances leading up to the shooting cast doubt on who was to blame. The Tampa Bay Times reviewed other stand-your-ground cases for similar circumstances, ignoring the fact that Trayvon Martin, ladies and gentlemen's case, was not stand-your-ground. Notice, John, they said the shooting cast doubt on who was to blame. Quoting again, the Tampa Bay Times reviewed other stand-your-ground cases for similar circumstances. This was not a stand-your-ground case to begin with. The Times relied on available information, some of which may not tell the whole story. When the situation was unclear, that was noted. And here's some of the information. Did the victim initiate the confrontation? Yes, in 104 cases. No, in 48. Unclear, disputed in 85 cases. Was the victim armed? 75 cases, yes. 160, no. 21 cases, unclear. Was the victim committing a crime that led to the confrontation? 51 cases, yes. 190 cases, no. 21 cases, unclear. Did the defendant pursue the victim? 70 cases yes, 119 cases no, 48 cases unclear. Could the defendant have retreated to avoid the conflict? 135 cases, 36 yes, 36 cases no, unclear and disputed 66 cases. Now I'd like to know where they were able to derive that information, do you think, on whether or not they could be retreated if again, it doesn't say.
Yeah, I mean, if it went to trial, then if it was a stand-your-ground case, then the duty to retreat didn't exist, and there would have been no jury question of whether somebody could have retreated.
Right. So, a little dubious there. I don't know how they came up with that.
It's also dubious. Why are they calling somebody a victim?
Well, there's a lot we could break down here, and John did a masterful job of that in front of the Senate. Was the defendant on his or her property? 69 cases yes, 168 cases no, 0 cases undisputed. Clearly, 69 cases on your property. Now, that goes back to what? The old Castle Doctrine, where stand your ground what? That is the basis of stand your ground. We all know that a man's home is his castle, period, correct?
Well, kind of. I mean, the bottom line is in most states when you're talking about no duty to retreat or stand your ground or whatever you're calling it, they almost always deal with when you're in a place besides your home, your automobile, or your place of business.
Okay, 168 cases, no. It doesn't say where those occurred. It doesn't say if it was a case like mine where I was out on the street at a traffic light. It doesn't mention that. So did someone witness the attack, as John said? In 154 cases, yes. 58 cases, no. 25 cases in question. Was there physical evidence? 127 cases, yes. 13 cases, no.
I don't even know what that means.
What, some type of physical evidence. It doesn't break that down.
Were these all cases where someone was actually shot?
Yeah, these were actual cases in Florida.
But were they actual shootings, or?
Yeah, and this is where
the
standard ground
just pulling out a gun and.
No, these were actual cases of stand your ground. These were actual stand your ground cases. And the other side of that, you can go through and actually click on each photo. Ladies and gentlemen, if you want to see this, it's fascinating. TampaBay.com/stand-your-ground-law.
The stand your ground applies to more than just killing somebody, shooting somebody. It can be as much or as little as just displaying a gun to stop an attack.
Correct. That can also be stand your ground.
You could be charged for something on the order of aggravated assault, and you could use stand your ground as a defense to that.
Correct. And we've got enough time. We can go into one of these. Here was about the case. The accused, a gentleman by the name of Damon Red Rock Darling, 21, black male, was found guilty. Leroy Yellowman LaRose. So we got Damon Red Rock Darling and Leroy Yellowman LaRose. Sean, you're laughing. 28-year-old black male. He took a plea. Here's what happened, according to the Tampa Bay. In July 1st, 2006, Miami-Dade County, 9-year-old Shardavia Jenkins was caught in the crossfire of a gunfight between two men that was possibly over drugs. The shooters were about 50 yards away from Jenkins, who was playing with a doll near the porch of her house. Darling said he feared LaRose would shoot. Let me get back over here. There we go. Said he feared LaRose would pull a gun on him, so he pulled his gun first, but was acting in self-defense. Now,
from 50 yards away?
From 50 yards away, and these were two men involved in apparently a drug deal, and we know that it can't be invoked. So what happened? It worked. He invoked it. He was found guilty. Clearly, there was no stand your ground invoked at all. He tried to, but it was not allowed. And Leroy Yellowman LaRose pled to the crime. So both men were guilty. Sean, you want to chime in there anywhere?
You know, like I said before, we're the Jesse Jacksons and the Al Sharptons when you hear something like this. Why don't they explain what's going on here? You know, why is this guy pulling guns and shooting? These people have no regard for any life around them. It's all about their stuff and what they're doing.